Good evening, everyone. Today, we have with us one of the finest medical legal experts, Advocate Dr. Rachna Bharadwaj. Good evening, Dr. Bharadwaj. It's a pleasure to have you here today. So, Dr. Bharadwaj is an advocate registered with the original side of the Bombay High Court. Her field of work is IPR and medical legal law. Currently, she is working as an independent legal and medical legal advisor and consultant. Her area of work is diverse and includes work in the field of oncopathology, HIV/AIDS, medical negligence and healthcare laws, IPR, drug trial regulations, and cyber law and cyber forensics. She has also written several articles in India Business Law Journal on issues related to patents, patent linkages, clinical trial regulations, and so on. She was also the AVP for Medical Legal at Reliance Medical Foundation Hospital. It's such a pleasure to have you here today, Dr. Rachna Bharadwaj.
Thank you, Dr. Kritika. It's always a pleasure to speak to the medical fraternity. Once again, it feels home. So I'm really very excited in starting my medical legal series as of now. And of course, today we are here to talk about assisted reproductive technologies. So today we are going to talk about assisted reproductive regulation, legal and ethical issues. Now, art has grown by leaps and bounds in the last few years, and India has the highest growths in the arts centers and the number of art cycles performed every year. Now, assisted reproductive technology, including in vitro fertilization, has given a hope to multiple of persons suffering from infertility. But it has also introduced a plethora of legal, ethical, and social issues, and this is what we are here to discuss today. India has, over the years, become one of the major centers of this global fertility industry, with reproductive medical tourism becoming a significant activity. And clinics in India offer nearly all the art services, gamete donation, intrauterine insemination, in vitro fertilization, and intracytoplasmic sperm injection. Of course, these activities have increased, and that's the reason why we need to really discuss the ethical issues. So the first frozen thawed oocytes was used in 2009 when a 25-year-old woman was, implanted with the frozen oocytes with the method ICSI, and a male child was born, which was a healthy baby. Now, of course, there are a lot of ethical concerns.
Dr. Bharadwaj, sorry to cut you in between. Can you just make your slides into a full screen mode, please?
Okay. So is that okay?
Yes, okay. Perfect. Thank you.
So, yeah. So why do we need to talk about the ethical issues? Because, of course, with this expanding work in the field of artificial assisted technologies, we find that, there were certain ethical and moral questions. Now, of course, with this comes, what are the rights of the unborn child? Does the child have the right to know about the biological parents? Then we also discussions around moral status of the embryo. Does it have a independent status? And how embryo should be handled in the event of divorce, death, or separation. There's a big challenge that is also thrown is in terms of what do you do with the unused embryos and how do you dispose them? And of course, sale of eggs, which has been happening because the industry is so unregulated. It is also an ethical concern because, as per some, it's commodification of human life. So these are relevant issues. Now, of course, infertility per se is a taboo in India. And, it was only when Diana Hayden at the age of 42 used this technique for her pregnancy, probably the barriers have sort of become lesser. So in that way, I think these are more popular now. So Now, of course, these embryo donation is a family building option for a group of couples in which the woman has premature ovarian failure or is a poor responder to traditional ovarian stimulation. And of course, if the man suffers from disturbances in gamete production. So the options for fertility are only for people who really would need it. And patient selection is, of course, a very, very important criteria in when we are discussing the ethical issues. Of course, it is also justified for couples who are carriers of hereditary diseases, which may cause significant morbidity in the child. Also, an egg donor is a woman who contributes her genetic material for reproductive purposes to another, and a donor does not intend to be a parent of any resultant child and waives any rights whatsoever. Donor remains anonymous, as does the recipient. Of course, we shall discuss what are the provisions available, whether anonymity is something which is across the board, or are there any exceptions that one can sort of make in these areas of anonymity. And of course, another area which is a challenge and always a contentious issue is the informed consent, which is to be signed by the donor, confirming that he has no legal rights whatsoever. So it's extremely important to get the informed consent. Then the donor is screened, of course, for Australian antigen, HIV status, and any genetic disorder. Now, the frozen semen samples are generally used after 6 months. So once the second HIV test comes negative, and they're not used to produce more than 10 children to avoid consanguinity. Of course, there is no limit to where the number of times a woman might donate the oocytes, but as per the Indian law, they have put in provisions that restricting the number of times a woman can actually donate her oocytes. It's very, very important to have the inclusion criteria for initiating these kind of treatments, and these are also very important within the framework of the new art regulation bill that has been passed by the cabinet. So clearly the indications are premature ovarian failure, women with natural menopause who have lost their children, repeated pregnancy wastage with chromosomal structural abnormality, repeated fertilization failures, and of course, poor responders in an IVF stimulation protocol. And there is an age limit to where these procedures can be done. So the woman has to be, say, around should not be less than 35 years, and she should at least have one child of her own. Of course, a lot of times, there are certain religious issues which come to the in these areas because the religion permits or does not permit. And these are the questions which the doctor actually has to confront. So it's interesting to sort of know these by and large. So we see that in Islamic law, it does not accept embryo adoption because procreation is considered as a sanction between a man and a woman who are married. So embryo adoption is not really permissible. As per the Jewish law, the adopted child may unknowingly marry his or her genetic sibling, resulting in consanguinity or also incest. The Catholic Church offers its respect and protection to the human being starting with its first second of existence. It considers zygotes, pre-embryo, embryo, and fetus as a person and strongly disapproves research on embryo cryopreservation and abortion. So here the laws, the Catholic Church is pretty clear on this. As far as the Hindu religion is concerned, I think they're more open to the idea of sperm and oocyte donation, but they say it should be within the close relatives. So that's again something which they prefer. Buddhism, of course, is more liberal in these issues. Now, embryo freezing and donation involves, of course, the donor couple, the recipient couple, and the offsprings, and raises certain ethical issues. Now, what are these? How strict should the criteria for selection of the embryo donor be? And we have seen that a little earlier. Which couple should be offered embryo donation treatment? How should the couple be? How old should the couple be when they are treated? So there is an age limit till where you can have these procedures done. Disposition of the embryo, of course, still remains a very, very big challenge because once the pregnancy happens and the child is born, the parents never get back. And so what do you do with those embryos? Because there is a huge cost that you incur in order to keep these embryo in a frozen condition. So it's important to sort of also, dabble with these issues of disposition of the embryos. Of course, consent and contract is the mainstay of the procedures that we do, and this is something which doctors need to really take cognizance of, because this is what protects them in a court of law. So we will discuss this, and we will see how is the contract or a consent to be taken. Now, the other question which comes to the fore is the embryos for research. So, can they be used for research? And also issues related to when there is a divorce, or when there is a separation, or death of one of the partners, or something like that. Then the issues need to be discussed prior to the procedure being done. So. Now, of course, these issues also need to be integrated into your consent forms, or your contract that you give your patient to sign, because there are definitely health concerns, because we know that egg harvesting under anesthesia, there are certain risks involved. Also, one needs to tell them that there could be ovarian hyperstimulation syndrome. Then, of course, informed consent issues need to be discussed with the patient. And commercialization or donation for exploitation of the donor against their best interest. Of course, buying and selling is immoral, so because this leads to commodification. So clearly, the health issues and the risk or the failure of the treatment, that it is possible that the treatment that you give might even fail. So that also needs to be explained to the patient. It's always a good idea to have these included in your consent form, which means that is a really, really informed consent, because once you've informed the patient, it gives them an option whether to go ahead or not, and that they have understood what is being told to them. Of course, coming to the anonymity, there's a great controversy, and of course, when most would choose anonymity, some people might say that the child, when he grows up, might want would want to know the biological parent, or so. Whether it's justified to let the child know about the identity of the donor. So, in one of the British laws, this had come forth, and the court ruled that children born as a result of assisted reproduction have a right under Article 8 of the European Convention on Human Rights to discover information about their genetic parentage. However, also there is, even the right to anonymity for the donor is a very valid law, which is protected under Article 8. So, of course, we see that there is a kind of a conflict here in the law. These are some of the issues which will even confront you as well. Of course, as we discussed, these surplus embryos, what do you do with them? So they can be either discarded, they can be donated for research, or if you sort of store them, it's incurs a high cost, and donating the embryo to the other couple for the purpose of uterine transfer is the other fate of the frozen embryo. Now, obviously, these, there in the United States, there's almost about 400,000 embryos which are currently cryopreserved, many of which are not even being used by their genetic parents. So this surplus of embryos creates a huge, huge cost on the medical establishment. So these are the concerns which need to be addressed. And fortunately, these ethical issues have been taken into consideration by the new bill that has been proposed. And so it's a very, very great news for all of us that, such a dilemma has been sort of obviated because of the integration into the laws. Of course, as I said, the Art Regulation Bill 2020, the sale, transfer, or use of gametes, zygotes, and embryo, or any other part thereof, and the information related, will not directly or indirectly within India or outside be divulged. So one has to sort of keep all these things, confidential. and sale and transfer is of course not permitted at all. Of course, since so far the industry was unregulated, so in India also there were payments being done for the eggs, and anywhere between 20,000 to 50,000 rupees. In the US, of course, I mean it's funny, but that's the way it happens there. So the USA donor is paid for a donation. So if you have a blue-eyed, blonde-haired Ivy League girls, they can get a great booty out of it, maybe $50,000 for just that. So, I mean, they make a lot of money in that. So there it is permitted, but in India, we don't. It's not permitted at all. So also there are issues related to whether the human embryo is a person. Now we all know that it in the hierarchy of cells in the body, the embryonic cells are higher up in the hierarchy. For obvious reason that they're pluripotent, they have a potential to give existence to a human being. So certainly, I mean, there have been debates in the ethical circles where you say that this is a potential person, so it will cause life at some point in time if it is given the favorable conditions. But some also argue that it is not yet a person. So whether that kind of that kind of hierarchy should actually be offered, and whether a status should be given to the embryo, I mean, is one of the ethical dilemmas that we have not yet come to a conclusion. So obviously, I mean, an embryo is a genetically distinct living human organism in itself, because it has the potential of going through the different stages of a human being, and so that is why we say that it is a potential for a human being, and many years later it will turn into an adult. So this is again very important. Okay, now also some of the concerns about the donor. I mean, if they're supposing they transmit a genetic defect to the donor, I mean, to the child, in that case, are they really liable? So one thing is, of course, genetic testing has become mandatory as per the new bill, and so it is important to do it. But otherwise, if they hide their status of having any genetic defect, it is problematic. So wherever the liability can be fixed, it will come under various sections to put the liability on the person. So of course, doctors also need to be very careful on this, because if they have not gone ahead with genetic testing, then they are liable, because it's a mandatory provision now. So even to the extent, even the licenses of these clinics can be cancelled. So it's very, very important to do these genetic counseling as a mandatory provision. Of course, in 2003, in relation to the fixing the liability, I mean, there was a case where there was a girl who had cystic fibrosis gene mutation, but the result was not really shared with the recipients. And when the child grew up, she said this is wrongful life, but the court said that the child cannot claim that this is wrongful life, but the parents can go for malpractice against the medical facility and the doctor. So one needs to be really, really very careful in these kind of situations. In India, the ART guidelines state that a third-party donor and a surrogate mother must relinquish all parental rights in the child. So again, these are important, because the person who donates cannot claim cannot claim himself or herself to be a parent of that particular child. As I said, embryo for stem cell research is very, very controversial. Of course, in India, I mean, the embryonic stem cell research ICMR has given some guidelines where embryonal stem cell research can be conducted. Obviously, the interest has grown in embryonal stem cell, because these are pluripotent cells which are being used, as a treatment for multiple disorders. Um, but the whole logic of sort of saying that you don't give these embryos for research is because embryos are actually themselves, when you're destroying a life. So, which actually would amount to homicide or a murder. Also, I mean, this would just treat an embryonal stem cell as object. So maybe objectification of life, and this is what the whole issue around embryonal stem cell research. Of course, in the child, by the reason of his physical and mental immaturity, needs specific safeguards and care, including appropriate legal protection before as well as after birth. And this was in the Declaration of the Rights of the Child in the 9th paragraph of the Preamble of Convention on Rights of the Child. So it's important that we sort of treat it with a lot of respect. Of course, the unborn child has a right not only to life, but also that they are persons. So, of course, these are again issues that revolve around whether embryo is a life in itself or a person in itself. And the debate, of course, is an ongoing debate which will sort of continue. Of course, as I said, ICMR has ethical guidelines on art, which allows stem cell research with informed consent from the embryo donor. And of course, if the research begins within 14 days of embryo formation. So this is again very important in the Indian context. Okay, so we have this very, very, detailed provisions of the Assisted Reproductive Technologies Regulation Bill 2020. This is for regulating and supervising the art clinics and the art banks and prevent the misuse and offer a safe and ethical practice of art services. And it's very, very, woman-centric. So these are some of the provisions of the Art Regulation Bill 2020. Now, of course, it has about 6 chapters, but I would restrict my discussion to Chapter 2, which talks about the authorities that are regulating the art. Then I would be discussing Chapter 4, which are duties of the art clinic and the art banks, which we really need to know. And of course, there is a Chapter 5, which is on offenses and penalties. So we would be sort of talking about these as well. Just to quickly, go through some of the important definitions in Chapter 1, we say that commissioning couple means an infertile couple who approaches an art clinic or bank for obtaining services that the art clinic or bank is authorized to provide. The couple means a relationship between a man and a woman, the age of 21 years, and the woman above the age of 20, the male being 21 years and the woman being 21, above the age of 21 years, and who are married or in a live-in relationship. Cryopreservation means the freezing and storing of gametes, zygotes, and embryos. Embryo means a developing or developed organism after fertilization till the end of 56 days from the day of fertilization. Implantation means the attachment and subsequent penetration by the blastocyst. Now, the national board, of course, it's important to know that there are the national board, the national registry, and the state board, which come into the picture. So the national board is constituted. The national registry, of course, we will go through it. And oocyte means naturally ovulating oocyte in the female genital tract. Of course, pre-implantation genetic testing, we all know. Now coming to the National Board for Art, it has its head office in New Delhi and is under the central government, and it can be established in any part of the country as per the regulations of the central government. Now, of course, it has national board members, will have the chairperson, 3 full-time members, and not more than 25 part-time members. Important to know because the chairperson is, going to be from the medical fraternity, so it's good to know. It shall be appointed by the central government from amongst the medical persons who have specialized knowledge of and professional experience in the field of art. However, one of the members has to be from legal background. Now, the chairperson, as I said, has a lot of powers, so we shall see what those powers are in the later part of my talk. Now, what are the powers and function of the National Board? Now, the National Board will lay down the code of conduct which are to be observed by the persons working in the art. It will set the minimum standards of physical infrastructure, laboratory and diagnostic equipment, and expert manpower to be employed by the art clinics and banks. And along with NABH, they will also be involved in the inspection and other investigative procedures. Also, it will act as an appellate authority for the National Registry and the State Board, and will pass orders as per the provisions which is made under this particular act. Again, we have another body, regulatory body, which is the National Registry. So now National Registry shall register the art clinics and the art banks in India, and you issue a unique number, and that will be given to the art clinics and the art banks. And of course, the National Registry will act as a central database in the country through which the art clinics and banks of the country, including nature and types of services provided by them. So all the outcomes of the particular art procedures will have to be informed on a regular basis. So, your entire data will have to be shared with the central database system. So it will be a central agency for all the art related documentation. Now, this the National Registry also will be a agency for cancelling registration in case it finds that a clinic or a bank is not following the rules or the procedures laid down in the art guidelines and rules. So it's a very, of course, they'll be given an opportunity to be heard. Of course, the data generated from the National Registry will be utilized by the National Board for making further policies, guidelines, and help in identifying new research areas and conducting research in the areas of art and other related fields in the country. So these are some of the important functions of the National Registry. Coming to chapter 4, we have what are the duties of art clinic and art banks. So patient selection, as we have seen, is very, very important. So the art clinic shall obtain donor gametes from the art banks. Now here the art clinics are very distinct from art banks. So far the practice had been that most of the clinics would have their own banks and cryopreservation facility, but here the art banks will be a separate entity and art clinics will be. So the art clinics will have to take gametes from the art banks. So this is something which, I'm sure this is a very, very difficult issue for people who have already established art banks in their clinics. So how do you how do you manage once this bill really becomes the act? Of course, another very important aspect is professional counseling, because it is very important that you have a professional counseling being done. So the person who is coming or the commissioning couple must know all the implications and chances of success of assisted reproductive technology procedures in the clinic. So do not give false hopes. It is very important to be very, 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 very transparent with the patients and tell them that the procedure could fail and there are limitations to the technique. Of course, also share the advantages, the disadvantages, and the cost of the procedure. Very, very important. Also explain to them that there are certain medical side effects. Also multiple that there is a risk risk of multiple pregnancies should be explained, and the possibility of adoption in infertile couples should be always given as an option before they actually go to the through the art procedures. And of course, anything that helps the patient making a decision and taking an informed choice of what is the best mode to have a child, whether it is artificial assisted reproductive technology interventions or whether it is adoption. So a doctor, I mean, has to give them all these and help the patient make a decision and not be very enthusiastic in, forcing their decision that they have to undergo, artificial procedures or artificial assisted technologies. Of course, also that the art clinic will have to tell the couple that to make them aware of the rights of a child born through an art. So and that all information will be confidential, and so the information, of course, can be shared only with the national registry at the request of the couple, or by the order of the court of competent jurisdiction. So these are also very, very important issues. Okay, coming to this very, very relevant and issues which is for doctors, it becomes very important to have the written informed consent in place, because this is what saves us in the court of law. That we explain to the patient that what is the procedure, what are the outcomes, what are the side effects that can happen, or what are the risks involved, and all such matters. Now, also, the banks shall not cryopreserve any human embryo or gamete without specific instructions and consent in writing from all the parties seeking art in respect of what should be done with the gametes or embryo in case of death or incapacity of any of the parties. So what is going to be the fate of these embryos has to be integrated and written in the informed consent. So that, again, is important. Now, the art clinic shall not use any human reproductive material except in accordance with the provisions of the Act. And of course, all these will have to be integrated in the specific consent in writing. And except for reproduction, if you're using it for, if you wish to use them for research, then you should have this particular clause included in the contract or the consent that the person, gives his consent to use it for research purposes. Of course, any of the commissioning couple may withdraw his or her consent under subclause 1 anytime before the gametes are transferred to the concerned woman's uterus. So, coming to the duties of the art clinic using human gametes and embryos, the art clinics shall harvest oocyte in accordance with the regulations of the National Board. The number of oocytes or embryos that may be placed in a woman during any one treatment cycle shall be such as may be specified by the regulations made by the National Board. Okay, so I mean, of course, there will be guidelines which the ICMR will issue on these. Of course, now the National Board will make it clear as to what these rules and regulations are. So it'll be amply clear, though it's not mentioned, the rules have not yet come into force. So we need to really wait for them. A woman shall not be treated with gametes or embryos derived from more than one man or woman during any one treatment cycle. So an assisted reproductive technology clinic shall never mix semen from two individuals for the procedures specified under the Act. Of course, also splitting of embryos for for twinning is not permitted because obviously, and also sex selection. If you have any procedure, you think that by doing fractionation, if you have X or Y gametes, and the outcome of the pregnancy is an intended male child, so that is not really permitted, and it's and also comes within the purview of the PCPNDT Act. The collection of gametes posthumously, of course, that should also be mentioned in the consent form of the commissioning couple. This is important again for doctors to know, because if you know these can well be in the as a part of the consent form. Also, clinic shall not use ova that are derived from a fetus in any of the in vitro fertilization. Of course, a mandatory provision in this particular bill that is that is implemented is that the pre-implantation genetic testing should be done irrespective of whether the patient wants it or not. So it's a mandatory provision now that pre-implantation genetic testing needs to be done. Of course, there are concerns that these are very expensive. So how many times would you and who pays for it? So it the cost of treatment really becomes very, very high. But in the current form, the bill has actually said that genetic testing is mandatory. The other issue, is that the donation can only be with the approval of the commissioning couple to an approved research laboratory for research purposes of an embryo. After pre-implantation, genetic diagnosis shall be done only when the embryo suffers from pre-existing heritable, life-threatening, or genetic disorders. So now, sex selection, of course, is not permitted unless, as I mentioned, only in sex-linked disorders or diseases. Maybe there it could be permissible, but otherwise, if you want to have a fraction enriched in sperms of X or Y variation, that is not allowed, and it's punishable under the law. It's completely prohibited. And nowhere, one can indicate that these kind of provisions are available at the clinic or with the banks. Okay, now also, what the banks need to really know is that, they should make sure that the semen is from the males who are between the age of 21 years and 45 years of age. I think probably this has increased to 50 years, but that was not in the bill that I was referring to. So that one could check on that. And oocyte from a female who's between 23 years of age and 35 years of age. Okay, and we have seen that Art Bank shall not supply the sperm of a single donor not more than in one commissioning couple, and oocyte of a single donor to more than one commissioning couple. Of course, the bill also mandates that a woman should be married and should have at least one living child of her own with a minimum age of 3 years, and can donate only once in her lifetime, and not more than 7 oocytes in one cycle, one retrieval procedure. So it's only about 7 oocytes in one cycle. Now, all the unused oocytes will be preserved by the Art Bank for use in the same recipient. So the donor gives it for this particular cycle, and this will be used only for one person, and not that this one oocyte goes to one person and the other and the second oocyte goes to another recipient. So that is not permitted, really. It's for the use to be used for only one recipient. And of course, there has to be a written consent from the commissioning couple. Of course, the bill is very clear that all such information will be confidential, and complete anonymity has to be maintained at all points in time. Of course, a very interesting topic. Instead of giving kind of a to prevent the sale and giving something in money. So that has been obviated, and we see that insurance coverage has been given to of such an amount which is in favor of the oocyte donor from an insurance company or an agent recognized by the insurance regulatory authority. So an insurance coverage is generally to compensate if in case of death or in case of any accidental things or any harm that is done to the patient, to the donor. of this particular procedure. So there is an insurance coverage which is being given. Now, coming to the storage and handling of human gametes and embryos, it will be as per the procedures that have been prescribed, and of course, the national board shall make sure about the conditions, whether the banks are in a position to really have have an infrastructure which will keep these gonads intact, and do they have facilities for doing all the battery of investigation. So this will be prescribed by the national board. Now, of course, another question when we talked about for how long do you sort of keep these embryos? Do you sort of keep them indefinitely? But now the bill has made it clear that it will not be for more than 10 years in the normal circumstances. Of course, there are certain conditions where if there is a contentious issue and there's litigation, then the embryos or the gametes need to be kept for till the final disposal of the matter. So then in that case, you'll have to really preserve these oocytes for a longer duration of time. We have seen this, that the sale, transfer, or use of gametes, zygotes, and embryos, or any part thereof, or information related thereto, directly or indirectly to any party within and outside India, is prohibited, except in case of transfer of own gametes and embryos for personal use with the permission of the National Registry. So none of the banks can go unchecked, and they have to follow, and all the data actually goes to the National Registry. The National Board has, the National Registry also has provision for, impromptu inspection that they can come, and if they find that there is anything that is not followed in terms of rules and regulations, the license can really be cancelled. Now, of course, the use of human gametes and embryos or the transfer to any country outside India is absolutely prohibited. The research on human embryo or gametes within India shall be as per the rules prescribed, so that there are, rules and provisions that the guidelines will come up with. Now, the rights of the child who was born out of art is the same as a biological child, and the commissioning parents are the biological parents, though they are not biological in that sense. They are there, but they never. The child who is born is the biological child of the commissioning couple, and it has all the rights and privileges available to a natural child. So, once the child is born, the commissioning parents can't even disown the child, because that's not the right thing to do, and that is not even permitted by the bill. Now, a donor shall, of course, relinquish all parental rights over the child or children which may be born from his or her gametes. Now, these, once the mother is, donating the child, and suddenly there is a kind of an attachment she develops that, she wants the child, there is no way, and that has to be amply made clear to the donor that there will be no, the donor will not have any right over the child whatsoever. Of course, one of the few things in chapter, I think this is chapter 6, by mistake I have written it. So, the assisted reproductive technology clinics or the art bank or agent thereof shall not issue, publish, distribute, communicate, or cause to be issued, published, or distributed, or communicated any advertisement in any manner, including internet, regarding facilities of sex selection, selective art. So sex selection is not permissible under any circumstances, and of course there is an imprisonment and also a fine. So imprisonment can be 10 years and a fine of 10 lakh or both, and subsequent, of course, cancellation of the license. The offenses and the penalties, of course, these are made very stringent, so that these are for the safety of the woman, and these are very women friendly law. It goes in favor of the woman. So offenses are also such that one doesn't misuse these practices. Now, any medical gynecologist, registered medical practitioner, or any person shall not abandon or disown or exploit uh, or disown the child born through our technology. They cannot sell human embryo or gametes, or run an agency or racket or an organization for selling, purchasing, or trading in human embryos or gametes. Of course, we have seen this being done in case of organ transplants. So now this is very much an integral part of the bill, which is a good thing to know to prevent all these malpractices. And of course, import or I mean, you can't import any embryo or a gamete from so these are very, very, one would be liable if one sort of does that. Exploit the commissioning couple or the gamete donor in any form, and transfer of human embryo into a male person or an animal. Of course, these sometimes when people think that, they want to experiment, maybe such procedures are carried out. But of course, I have not heard of cases where such a practice was ever done. Of course, all these are provisions, but notwithstanding the other provisions that are there in the Indian Penal Code. So if there are provisions of Indian Penal Code which come into action, then that act comes into the provision. If it is any other law which is flouted, and or there's a medical negligence, there will be. Those laws will come into the picture as well. And of course, as we mentioned, that the minimum penalty can be 5 lakh rupees, up to 10 lakh in the first instance, and imprisonment or imprisonment for up to 10 years, or 10 lakh rupees, or even 20 lakh rupees, and cancellation of registration. All these offences are, of course, cognizable offences, so one can be arrested without any warrant. So very tough provisions in this area. Of course, the other laws, as I mentioned, will be the PCP and DT Act of 1994, the Clinical Establishment Registration and Regulation Act of 2010, and the Medical Termination of Pregnancy Act, or any other law which I talked about, the Indian Penal Code or the Criminal Procedure Code, or negligence when it comes to certain matters. Okay, now coming to the some very brief talk on just the provisions which have been amended. So this bill has become an act, and it's now the part of the MTP Act. This was passed in March this year. The bill allows abortion up to 24 weeks of gestation for vulnerable categories of women. So women who have been raped, women who have weak health and cannot carry their gestation for some reason, or so those will come in the women in the vulnerable category. Of course, there is now no limit to gestational age in case of pregnancies with substantial fetal abnormalities which are diagnosed by the medical board. So clearly, the provisions of the MTP Act will be in place. So it will be a panel of doctors when they certify and say that the woman can undergo medical termination of pregnancy, and to be looked into that, and then the decision can be made. Of course, if there's a failure of contraception in married or unmarried women, will also be a valid reason for abortion. So we see that, it's very, very woman friendly, and it's given the rights of right to the women to terminate their pregnancies. Of course, the bill will ensure the safe termination of pregnancy, and also gives women reproductive rights over their bodies. Now, also the government has agreed to a long-standing demand from women health groups and risk groups with its decisions. So now this has been, in the area of reproduction. These have been certain ethical concerns, with unwanted pregnancies. So the government has taken cognizance of that and come up with this law. And if we see that, India actually is amongst the nations with which these laws now are highly progressive laws which allow legal abortions on a broad range of therapeutic, humanitarian, and social grounds. Of course, we don't see that in a couple of countries. Say, you have Angola, you have Thailand, Philippines, Madagascar, Iraq, which do not permit abortion at all. Of course, there are other very liberal countries which, like Brazil, Mexico, Sudan, Indonesia, and Sri Lanka, which permit abortion and when the woman's life is at risk. So, in about 97% of the cases, when it's the woman's life that is being threatened, the abortion can be done, and so I think it's great to discuss these issues. It's good to know them, because these are something which geneticists and gynecologists, before they sort of open clinics and banks, they need to be aware of what their rights are, what their duties are, and this is what will prevent them from any litigation in the future. So this law is really good to know. It has been a pleasure talking to all of you, and I would be very, very happy to take any questions from any one of you, or any comments if you would like. Thank you very much. Thank you. Okay, so I have some questions here. Okay. Are there any rules for surrogacy attempts within the family? Of course, I'll be talking on surrogacy laws, and we will sort of then talk about the entire gamut of what are the surrogacy laws that have come. But we'll talk about it in details, when we come to the surrogacy laws. Okay. Okay, the next question is, what are the footfalls in the Art Regulation Act that need to be worked on? Well, I don't see the question is very clear. What is meant by footfalls in the Art Regulation Act? It's not an act as yet. It's just a bill, and what are the legal implications in case of alleged misuse of human sperms or embryos? Of course, we have seen that. If it is sale, transfer, or any other, something which is not permissible as per the act, then there is a punishment. There's a punishment, and we have seen that it is anywhere from 5 lakh to 10 lakh to 20 lakh rupees, and a 10-year of imprisonment. So misuse of human sperm or embryo is not at all permitted. Sibling conception, please highlight relevant medical legal points, asked by Dr. Prakash. Well, sibling conception using sibling conception, I don't think that issue is addressed really. But for the fear of consanguinity, we will really not go in for conception as far as the siblings are concerned. So that is something which is inherently, if you see medically, I think it is not really permissible. But unrelated, in surrogacy, we will see that how they can conceive the child, but in a very permissible kind of picture, and not sibling conception. So it doesn't talk of sibling conception, but I would feel that the medical fraternity itself would not really encourage such. But I think this question is more relevant in the surrogacy, where can they be a surrogate? Yes, they can be surrogate. but using the gametes, like the siblings cannot use each other's gametes, so that would be incestuous relationship, and I think that would not be permissible. But that's a good, interesting point. Okay, so are there any more questions, or are we done, Dr. Kritika? Okay, so I think we have no more questions. So thank you once again. Docplexus, of course, is a wonderful platform, and it really takes very challenging topics and topics of great relevance. And thank you very much for giving me this opportunity. And thank you, everyone. Have a wonderful night ahead. All right. Bye bye.